Guest speaker who's going to talk about some of the legal risks and compliance risks related to this application that every company uses all the time. So with that, I'd like to welcome Bob Kmors from Thelen, Reed & Priest. It's one of the largest law firms in the Bay Area. And I'm going to be here all night, so if you have any questions about MirrorPoint or want to learn about our technologies for dealing with some of those liability risks, I'll be around. You can grab me or Lynn Sakamoto from MirrorPoint. We're also sponsoring the beer and pizza tonight afterwards at BJ's. So it's on us at 9:30. So
Thank you.
With that, I'll give it to Bob.
Okay.
Ready to roll. Thanks.
All right, thanks. Okay, I'm just going to talk about some of the problems that I've seen in my law practice with clients that relate to email and internet usage. Lawsuits won and lost, problems the companies got into jams with their employees, their former employees, and other companies. But can I see just a show of hands of how many of you have ever been involved with a litigation related to your work at all? Just one of you? Not that many of you. Well, okay, 2 of you. Okay, well, it's a couple. It's probably less than I would have expected, but for whatever reason.
I think sysadmins are naturally litigation averse.
Well, right, but I mean, I would expect you, if the company was involved in it because of the important role that you play, many times you'd somehow be brought into it, and just, if nothing more, to be asked for information or to recover email or to how to recover electronic documents or stuff like that. I guess I would have assumed that.
Well, perhaps the question could be reworded to ask how many of us were ever involved, for instance, in gathering evidence for litigation or something like that, which is a little bit less directly involved.
Okay, well, that's what I mean. That kind of involvement. Anybody? Okay, a lot of you. Okay, that's what I expected to see. That's about what I expected to see, because that's very typical. I haven't been involved in a litigation in the last 10 years where we didn't have to make a visit with at least the head of the IT department for the company and ask a bunch of searching questions about, well, gee, how far back can you show me email and gather email incoming, outgoing? How does the company store its electronic documents? What's the best way to preserve that? How can we search it to find the stuff that matters? These things come up in every case, and they come up all the time. So I'm glad there's a lot of you in the room that have a baseline on that, because that's really what we're going to talk about. And if you have a question or even a comment, just bring it on out. I mean, we're a small group. We might as well learn from each other while we're doing this. I've punctuated this with a few pictures I took this summer. I climbed Mount Whitney. I'm very proud of myself. This is my 5th attempt. You know, it's not so big of a deal, except if you failed 4 times. But I did. Good case, bad email. So I guess the point here is that somebody in this room, and this is just, maybe this won't happen, I hope it doesn't, but somebody I predict in the next 5 years, somebody in this room, their company, will lose a lawsuit because of something that's said in an email or an electronic document that's stored on the server. Why do I say that? Because people say things in email that they shouldn't say. So a lot of times they say things in email they don't even mean and aren't even true, but gee, it becomes evidence. And juries love it. It can happen when you're trying to bring a lawsuit against somebody. You have a really good lawsuit, and your company's been hurt, and they need to recover some money to make them whole, but they don't do it because of something dumb somebody says in an email. Well, gee, you know, that contract or that loss of that technology didn't hurt us. That was outmoded technology. We weren't going to sell that anyway, or the customer we thought we had for that, we know from other information wasn't going to buy it. Those kind of things, if they get sent an email, normally they will be read by the person you're suing, and that cuts out an element of any legal claim called damages. So you're not going to have that claim anymore. You're going to lose your case. Can happen in a case that is brought against the company because of some kind of an admission. They have a really good point on this claim they're making in the lawsuit or whatnot. The way that this is supposed to happen in the best of all possible worlds, which of course I live in, and is that there's only supposed to be a very small clique of people that are allowed to send emails regarding the issues in the lawsuit. We don't want the company conversing about the lawsuit at large. There should be a litigation team. It should be designated individuals. It should be shielded by the attorney-client privilege. And if all these things happen, then the company's exposure will be no more than it should be. But on the other hand, if everybody's gossiping about the issues in the lawsuit, through email, internet blogs, internal postings on the intranet or so forth, then you can have problems. I saw a hand, yes sir.
Could you talk about this and also in terms of how long you have to keep things for IM and VoIP?
There is no absolute answer about how long you have to keep things. People ask me that. You know, gee, is it 5 years? Is it 7 years? Is it 2 years? It depends on the circumstances, and if the company is in litigation or is planning to have litigation, the lawyers for the company should address that question directly, and because there's no generic answer, it depends on, there's so many possible permutations of a right answer to that I can't answer it in general. Yes, sir.
I read a number of years ago an opinion in an airline magazine of all places, which I believe the author was either a lawyer or a law professor, commenting on retention policies and how the key element at that time, this is a number of years ago by the way, the key element at that time was that your policy, you must not change your practice near when litigation becomes imminent. So the best recommendation he could give you was basically have the absolute minimal retention policy that you possibly can. Have a policy that says we wipe out all email after 30 days or 10 days or whatever, the absolute narrowest you can for your business case will reduce your legal risks, your exposure in evidence gathering.
Well, that's
that
a
has
theory.
To obviously be weighed against your other business concerns.
That is one theory, and like I said, the best way to deal with this is to let the lawyers in the company converse with management and come up with a plan that works for your company and your situation, because there are so many different situations. For example, I could think of many ways where that wouldn't be the right thing to do, because your email may be the stuff that you use to defend yourself with. That may be the way that you prove that you weren't doing something that the other side's accusing you of. And if it doesn't exist, you don't have written proof, you've only got word of mouth. So all I'm saying is it is a major issue in litigation today. And let me go on to a couple more slides that have to do this. Why is it good evidence? It's mainly good evidence because juries love it. It brings an element of excitement. They think it's real time. They think it's the hot stuff from the horse's mouth. May not be, of course. It may be just idle gossip. It may be from people that have no knowledge at all. It may be from people who are not the decision makers about that. And it shouldn't be given the credit. But my perception is that it's given more credibility in many cases than it actually deserves. So let me get you back there first.
There's the absolute lack of any authentication that anybody, any real person ever sent this mail have anything to do with perception of its validity.
Well, no, you can prove that up. It can be done.
I'm assuming that the mail doesn't have an electronic signature.
Well, all you need to give, all you need to put an exhibit like a piece of email into evidence is some level of proof that it is what it purports to be. It's called foundation. If you do that, then the trier of fact, which can be the judge or jury, then gets to listen to all the evidence. Somebody will come and say, well, this isn't real, this isn't valid, it was phonied up, or it didn't mean what it said, or it was never received by the person it was sent to. You get to put that in. But because the stuff can be so devastating, if it says something directly on a point that's being litigated, once the jury sees it, I mean, how many have been on jury duty? You know, who's on jury duty? You know, is it besides you? You know, many times the juries are made up of retired people, sometimes, often as very unsophisticated people that have no knowledge of the technologies involved, that have no knowledge of the issues that might be going on in the case, that are merely trying to do the right thing in a limited amount of time, and they pay a lot of attention to email. So I guess the point is, what's the bottom line of this? The bottom line is that the company needs to have a way of, they need to have a policy, and they need to acquire technologies that allow them to control this and to manage this in an effective way that meets their needs. You don't just it's not the right thing to just have no email usage policy, never to check up on what people are doing, and let them do whatever they want to do, and then wait till you get into a litigation and the stuff starts being gathered up and looked at by your attorneys to say, oh my God, what have we done? That's not the right approach. So I'm just trying to highlight the problem, and then it's gonna be really up to you as the IT professionals and the lawyers for the company and the management of the company to figure out methodologies and management techniques that address these issues.
Excuse me.
Question on the floor?
Okay, sure.
One of our responsibilities as administrators is backing up systems. And oftentimes you have a backup policy that is counter to a document retention policy. Is there a legal thing that says even though you have tapes in archive, the official retention policy is a month, we can't use this evidence? Is there any way to protect the, without destroying your backups, protect the integrity of the backup retention policy?
Well, let me just talk to that. I'm not sure I quite understand the problem, but I'll tell you the issues that I've seen, okay? First of all, you have the problem where you're backing up the hard media and they're rotating the media so that you've got, like, this is not real, but say there's 10 tapes and every week you overwrite a tape, so your backup only goes 10 weeks back. You know, is that a problem? What I typically will do is if the company gets into litigation, I will meet with them at the very outset and I will say, well, okay, now you've got to change that backup policy. Now you can't destroy stuff every 10 weeks. Until this lawsuit is over, you've got to add how many other media it takes and don't overwrite, because overwriting is a method of destroying, and that should not be going on when litigation is either occurring or you know it's going to occur, it's likely to occur, something like that. Is that the part of the point you're talking about?
Not quite.
Okay.
The idea would be that if you had an official company policy that said we destroy documents after 1 year,
Okay.
but you retain backup tapes
Yeah.
because that's kind of counter to the retention policy, could that be called, could someone suing you call for those backup tapes even though that's counter to your retention policy?
Sure, absolutely. When you're in a litigation, they can ask for anything you've got. And with very few exceptions, you gotta turn it over.
Do
But-
most of these people understand that there's a difference between the actual trial processes and discovery? I wouldn't be surprised if they
The
don't.
people in the company?
No.
Or
No.
people here?
Yeah.
I think most of us do, but go ahead.
Well, when a lawsuit is filed today, it may be a year, 2 years, 3 years, 5 years before I actually get to trial, before I'm picking a jury and starting to make arguments to the jury and call witnesses. But just about from when the lawsuit starts down to the time of trial is what's called discovery. And that is a period where both sides get to request and are required to exchange documents, information, answer questions, people sit for deposition. It's very typical during a deposition for the company to be asked to produce a witness that's the most knowledgeable or completely knowledgeable about the IT system, the tape backup system, the electronic backup system, the email backup system, the email distribution system, searches that could be done on the available system, at which time you would be called, or you know, whoever has that information would be called into a deposition room and asked questions for a day probably by a lawyer that's adverse to your company to find out exactly what you do. Is that on your point? About discovery and trial, I'm not sure that
But the rules of discovery allow for very deep probing
absolutely.
of both sides.
Absolutely.
Right, and it's very different from a trial environment. And actually, you're much more exposed during discovery in some ways than during a trial, and many people who have not been involved in this are not familiar with that.
What the gentleman is saying is absolutely true, because during the time, trial is relatively short, discovery is very long. And during discovery, there's months, years, days, weeks to ask questions, to take depositions, to get documents, to look at them. Trial is usually short, discreet, and by that time, all the searching is done. You're all already, lawyers such as me, I'm not asking new questions at trial. I've already asked these questions and got the answers under oath and on a piece of paper long since from the other side. When I go to trial, if you give me a different answer that you gave me in your deposition, I just push a button and play back the videotape of what you said at the time of the deposition. So that's the difference I think he's talking about. Yes, sir.
This is just something that a lot of people might be monitoring, a particular case that might highlight the difference. How many people here are reading Grok Law on a regular basis and following the SCO case? Not as many as I would have thought. Okay. So the whole thing is that all of that has all been discovery so far, and it's not slated for trial until who knows when.
There's many other cases that are followed on a daily basis or even an hourly basis by means of blogs and so forth, and so people really
Grok
get
Law
into
is
that.
the one that covers a case that a lot of people here would be aware of. So.
Okay, well, let's go into a couple other things. Let me get to you in just a second here, because I got 30 minutes to get done here, so I gotta kind of move along. The most baseline thing, the most baseline don't do is don't infringe copyrights by means of your systems. That means that, you know, downloading of copyrighted materials, transfer of copyrighted materials, you've got to have a system in place that prevents that. People really like to do this stuff, and it can really get the company in a lot of trouble. So we've been talking about email and electronic documents, but always remember that this is an area of exposure for your company, and remember that you got to do something to monitor this. Okay? You had a question, go ahead.
Yeah, one place I've worked in the past had they had a secret email server for certain very high-placed people in the company. It's a company that's been in some litigation all the time. They're large and known for being kind of a pain in the ass. No one was supposed to know about this. What is the legality of such a?
That's not even the question.
Well,
if that's discovered.
it's certainly legal to have it. You can have a limited server for high-level people or any people you want.
No, I know why the server was there. It was there so that it never existed.
Yeah, that's a problem. And typically they'll get found out about it, not always. What happens is somebody has to declare under penalty of perjury that all the written questions have been answered accurately and all the documents have requested, a reasonable search has been made and turned over. And almost inevitably, unless the opposing lawyers were very untalented, all such items would have been asked about and asked for turnover. So somebody would have had to sign, I declare under penalty of perjury under the laws of the state of California that this is complete, and they would have to know that it wasn't complete, okay? So that means that they'd be perjuring themselves. Moreover, they'd be answering on behalf of the company, and the consequences of that could be a criminal case for perjury against the individual concerned, number one. A criminal case for perjury against the company because it would be corporate policy that did that. It's unlikely to be just one person acting alone. It could be an action by the court to cause them to lose the lawsuit if they were the defendant. It could be an action by the court to make them go away without winning their lawsuit when they otherwise would have won it if they were the plaintiff. Those are the immediate consequences that come to mind. So there can be severe and immediate penalties for such nonsense. You know, no corporate lawyer that I'm aware of that's like an outside lawyer or an inside lawyer would countenance such a thing, because the consequences, let's just assume it was a public company.
Oh, yeah.
I mean, if it's a public company, you don't just lose the lawsuit, okay? You get Sarbanes-Oxley because you have made disclosures about the lawsuit and the materiality of the lawsuit. At some point, you've disclosed to the SEC, yeah, gee, we have potential liability or we have no potential liability. Well, one of the potential liabilities that isn't disclosed is this big lie about the secret thing you're holding back. So you could get, shareholder derivative suit, action by the SEC. I mean, there's big sort of waves that can come off this, bigger than just the lawsuit itself. It can have consequences for the value of the shares, which then has consequences for shareholder, derivative class action suits, and okay. I think you.
Oh, yeah.
Yes, ma'am.
Why would the company be liable for copyright infringement of music files by their employees.
Well, why would they be? You know, I can't point to a case where they would be exactly on music files. But at some point, management, you probably wouldn't be if you totally didn't know about it, okay? But that's usually not the way things are. Usually you do know about it, and at some point, I mean, what lawyers do that want to recover a lot of money, which we like money, you know, they like to push boundaries. If they can find that management knows that somebody is running a Napster, you know, out of your office using your servers, they will see that as an opportunity to sue the company for copyright infringement because the company knew about it and didn't take action to stop it. So at some point, you cross the line from what the company legitimately didn't know about and what the company was closing its eyes to. The more common exposure is transfer of copyrighted materials such as books, manuals, and treatises that are like if you buy a book, and gee, it's really nice if everybody knows what's in chapter 3, and there's 1,000 of us, but we don't want to buy 1,000 copies of this, so we're just going to PDF chapter 3, and we're going to send it around to these 1,000 people. That's a copyright violation. That's a pretty direct copyright violation that would absolutely fall at the hands of the company if it was an employee that did it. Because the purpose of circulating that is for a business purpose of the company.
Well, I definitely agree with you there, but I don't agree that a company would be held, I'm a lawyer also, and
Yeah.
I too like money. But I don't agree that a company could be held liable for the infringement by their users if users are, let's say, downloading music from some popular file sharing thing. And given the extremely low risk that the company would get in trouble for that, I think wide-scale monitoring of the employees kind of goes overboard. In fact, having a policy whereby you monitor your employees may actually mean that the company's taking on a responsibility to catch copyright infringement, whereas if they don't have such a monitoring policy in place, you're better off.
Well,
I'd say
It's another view.
since it isn't a court and neither of you is a judge, then it would just be something that would have to be decided in court. And
I guess
you're both
my-
welcome to go fight.
I guess
out
my
the
point
process.
is, the way I approach things like this is not to try to figure out whether you could be held liable. My point is whether you could get sued. Because getting sued in today's world is just as expensive and painful as losing in many cases. Because why? You have to pay the lawyers.
Wouldn't the chapter 3 example that you gave have been a clear example of fair use back before DMCA?
No.
Not 1,000 copies, no.
No.
All right, loss of your trade secret information is always something to watch out for. Let me go skip ahead here a little bit. Halfway there, okay, we're halfway up the mountain.
Does trade secret have protections?
Oh.
I mean, certainly if you copyright something or if you trademark or patent something, you have protections. But if you just have a secret, what legal
Well,
protection is there?
Part of what makes it a secret is that the person to whom you disclose it, you have a contractual obligation that you've made them sign an NDA of some sort that holds them responsible for keeping it a secret. So if it's disclosed improperly, if you've taken the proper precautions in disseminating the information, then if it's disclosed, it must have been done so improperly. Therefore, you have somebody to go after. Whoever it was that signed the NDA and then let it out of the bag.
Best classic example is the formula for Coca-Cola. It's never been patented, it's a trade secret. And that secret has been maintained for over 100 years. And if it ever got out, Coca-Cola would have damages because it's a trade secret and it would be devastating to their business. Because it's not patented. Once it gets out, anybody can copy it legitimately. So that's the kind of thing we're talking about in trade secrets. No company has the finances to patent everything that they do. And actually, if you looked at
Seems to make a pretty good change.
the total quantity of intellectual property that exists in the valley, let's say, or exists in any company in the valley, 2%, maybe 5% of it's covered by patents. It's the most it could possibly be. If it's a software company, it's all the source code is automatically covered by copyright, but it may also be covered by patents. But for sure, it's also covered by the sort of redundant and residual protection of trade secret. In order to maintain trade secret protection, you have to treat it as a secret. There has to be measures taken to maintain the secrecy of it. Limited access, no public exposure of it, and so forth. And if you do that, then you can have you can have damages and injunctive relief, or in other words, an order to stop doing whatever it is that they were doing. This is an actual example, and I like to use this because it's so fresh in my mind. This actually happened at a client. What happened was one night about 8 o'clock or something like that, the CEO of the company was walking through the halls of the company and happened to just be looking at the papers that were sitting on top of a printer in the hallway. And right on top of the printer in the hallway, he saw the letterhead of their main competitor. And he said, what could that be? Let me look at that. So he picks it up, and then he picks it up, and it says, name of the competitor, and it says confidential, and it's filled with a bunch of confidential information from the competitor. And he says, oh my gosh, what is this? How did this get here? And he calls up his corporate lawyer, and who calls me, and eventually, here's what we figure out. They have hired a person from the competitor, which happens a lot. And this guy, when he came to work there, he was told by management, don't bring anything with you from the other company. We're just bringing you over for your skills. We don't want your customers. We don't want your trade secrets. We don't want your Rolodex. We don't want your marketing materials. We don't want your technical materials. We're just hiring you for you. That's the way we want you. Sign the paper saying that. The guy shows up, starts work. But what he has actually done is he brought all of his stuff with him. He brought everything that he had written and had come into his possession from this prior employer. And he had got on the Unix and segregated out a piece of memory just for himself, loaded it all up on the company's Unix system. He also had it on CDs on his floor, and he had it on his hard drive of his computer. But the only way the company found out about it was just by this accident. So then the question became, oh my gosh, are we going to get sued, or are we going to have a problem here, or what do we do? That was a case of criminal trade secret theft, pure and simple. This guy had stolen the trade secrets of his former employer and had tried to take them with him to help him at his new company. What the client did, or what we did, is we basically called up the competitor and said, here's what's happened. How can we fix this? We're not using this. We didn't ask for this guy to come over. We didn't want this stuff.
Basically, you sold him down the river.
Pretty much.
As he justly deserves.
Got the district attorney to have the cops go out to his house, do a search, find what they could find. They came to the workplace, and we turned over everything we found. And I don't know if he did time or not, but that's the consequence. It turned out to be a reasonable way of managing it for the company, because although there were rumblings from the competitor about suing them, they actually finally, at the board level, the two boards actually talked to each other, and board members from our client talked to board members and said, look, this really we did the right thing. What would you do? But the only good thing about it was that when we looked in the boxes on his floor, we found trade secret material from the guy's 3 prior employers, which of course meant that they couldn't do anything to us, because if they did, it would also show that he'd been using the employer before's information at them.
Right.
So
that would open them up to some interesting cases.
Yeah, it would. And I'm not saying that's the only reason. Even though I've become a little cynical from doing this for a long time, it actually turns out that a lot of times people really do the right thing. And I think this is one of those cases. But I think the point for us is that people really do stuff like this in the real world. So what is the reasonable monitoring plan, inspection plan? What are the rules for when people can segregate out a piece of memory on the Unix and store stuff there? And does anybody get to check that? Was the system administrator negligent for this company? Should they have changed their procedures or never had procedures that permitted this in the first place? You know, it's a rhetorical question, I guess, but, sorry?
I was gonna say, the easiest way to prevent that is do not let other people bring in the laptops from home.
Well, this was a lot more than, this is a lot more than that. I mean, he brought boxes of CDs, he brought in a thumb drive, he had,
Leave all that equipment at home. Nothing comes into the office.
nothing physical comes in, okay?
No telephone, no cell phone, no nothing.
Boy, I'm glad I don't work anywhere near you, because I certainly wouldn't be getting any work done.
Well, you know, at this point, in our lives, you know, I could store data on this thing and bring it in. I mean, if I want to get it in, unless you're gonna strip search me, you know, every morning and every night, I think I could get it in.
Yeah, so you're seriously saying that every company in the valley should not allow people to carry their own PDAs?
And internet access, you have to cut that off too, remember? Of course, production would probably go up if you cut internet access on.
And everybody's cell phones.
You can't bring in punch cards. People start wearing this as earrings.
I was asking around the office for examples of what other companies do, and one of my partners, who's a labor lawyer, brought, or actually my IT manager brought this. I guess he's got IT friends in other companies, and you see the point of this is if you send, stockbrokers have to monitor their email to prevent their brokers from making representations to the buyers of stock that won't get them in trouble.
Right.
And so just for fun, you know, you did this, gee, you know, sure thing and whatnot. Because if he sends that kind of email into Merrill Lynch, Smith Barney or something like that, it's going to trigger a whole bunch of series of alarms. And it's just sort of comical in a way. But I think that there's a good point here. And that is that these companies, because of the exposure that arises from email, have structures in place that pick up stuff like this. And so I just put this out here. Maybe you want to think about whether that applies to your company, maybe it doesn't. I don't know. One thing you might think about is if your company is one of these companies that has an arch rival, you know, a competitor that is life and death fighting you, and you see that, and maybe what you would want to do is set up some sort of a trigger that if that enemy's name appears in the subject line of an email or something like that, maybe you want to know about that. I don't know. It's not a very sophisticated approach. There's probably better ones, but something to think about. Boring old labor law, or how your company can pay college tuition for 2 lawyers' kids to Stanford. That's your company and the plaintiff's lawyers at the same time. Good deal for the lawyers, maybe not so good for the company. A lot of things, there's privacy violations, sexual harassment, discrimination, all can be documented. Here's what I think after having seen a little bit of this, and not a lot because I'm not a labor practitioner, I'm an intellectual property litigator. Any horrible thing that people are going to do, they will do in the office during working hours with your system. Why that is, I'm not too sure, except I think that internet usage, email usage, and computer usage in general has this sort of illusion of secrecy and privacy that is just that, an illusion. But people will do this, and they do this stuff all the time. Okay, we're just about out of time. What can you do about it? Have a good internet policy. If you don't have one and you need one, see me. My cards are out there. Bang, bang, bang. I'm getting the time being cut off here. Everything's downhill from here. Beautiful shot. This is from the backside of Mount Whitney, by the way. And there I am. That's it. All right. Awfully good talking to you. I got to run. Thanks for the opportunity.
Will these slides be available?
I can make them available. If you want to flip me an email, my cards are out there. I'll be happy to.
There's a website for Lisa slides.
I can make-
that's right. You were going to do that.
I can make sure they get up on the site.
Just know that they are copyrighted. It says so in the little corner.
Yeah, you want to be careful about that. I give you guys here in the room free use, though.
For yourself and your family.
I guess where we're from.
Willis, you could probably tell from this little, can you guys hear me in the back there?
No.
Is this microphone what I'm supposed to?
Yes, that works.
This one works, or this one works?
Where's the wearable one coming?
Right there.
Let me suit up with this.
It's on one of them.
Okay. You guys can hear me now, right? Back there? Okay, cool. So as you can probably tell from this little display, I am not a system administrator or a technology person. I'm a lawyer. But I am a lawyer who dabbles in the field of technology. I got into this field from being a criminal defense attorney. And I was representing people charged with all sorts of crimes, and I decided that I would be interested in learning more about computer crime, and this was in 1996, so it was a relatively new field then. And I started to go to conferences and try to learn about things having to do with computers and computer hacking and that sort of thing. And that interest got me involved in the world of computer civil liberties, because you may not know this, but pretty much everything about what you do as a criminal defense lawyer has something to do with civil liberties. And when you're representing people charged with computer crimes, you're involved in the field of computer civil liberties. And this was a really exciting time to be interested in this type of thing. It was back before, after the Communications Decency Act was passed, but before the Supreme Court ruled that the First Amendment would apply to the internet, and so there was just a lot of legal uncertainty and a lot of good work to be done. From being interested in that sort of as a kind of as a hobby or a side thing, I ended up getting offered the job that I have now at Stanford. And at Stanford, I'm the executive director of the Center for Internet and Society. My job there is to run the program, and we have conferences and speakers and that sort of thing. And I also teach a clinical class there, which is a place where we provide pro bono legal services to people who have cases that involve issues that deal with the intersection of the public interest, civil rights, and computer technology. And it also gives students at Stanford Law School a chance to practice some legitimate legal skills so that they can learn how to be better lawyers when they get out of school. So it's great for me because I can work on cases that I think are interesting without having to worry about whether the client has any money to pay me. It's great for the clients because they get free legal services, and it's great for the students because they learn how to be good lawyers. So being in this job and being in this field has enabled me to be involved in some really interesting cases, and I'm going to tell you guys about one of them today and sort of talk some about the kinds of things that I'm thinking about these days and that I'm working on. So, let's see. I'm going to talk about two things basically and kind of try to tie them together if I can, and do this all before the beer is served. So this is going to be a bit of a challenge. I'm going to talk today about a case where I represented a security researcher by the name of Michael Lynn, who was sued by his employer, ISS, and Cisco. I think Cisco you've probably heard of. And this is a legal battle that ends up having a happy ending. So I'm just going to tell you right now, for those of you who might be worried, oh my God, what happened? It's a happy ending. And I'm going to tell you about my next project that I'm working on, which is somehow related to the Mike Lynn Cisco case, which is about cell phone unlockers and people who want to access the firmware in their cell phone to go on any kind of network that's convenient for them, that has the right signal strength and the right cost. And this is going to be a legal battle with an unknown ending, and I'm going to talk to you a little bit about that and what might happen there. But why are these two things the same? What does Mike Lynn and Cisco routers and flaws in the routers have to do with cell phones? Well, there's a common issue, and the common issue is, what are you allowed to do with technology that you legally possess? And this is like a real battle in the internet civil liberties world today. What can you do with stuff that you legally own? Okay. And we're going to have an answer to this by the end. All right. So in July, I was speaking at the Black Hat Conference, which is a security conference that's in Las Vegas every year. And at that conference, a young man by the name of Michael Lynn gave a presentation. Now what happened here was Lynn worked for ISS, which is a company that does security research, and ISS was working on Cisco routers. People knew that Cisco routers had some security flaws in them and wanted to know exactly what the parameters of these security flaws were. It was hypothesized that the router flaw was so serious that an outside attacker could execute code remotely on these Cisco routers, but it had never been done before. And this was the project that Michael Lynn was working on. Well, he found out how it could be done, And he wanted to present this information at the Black Hat conference to tell people about the problem. Now there's a couple things you kind of need to know about this. One is that Cisco already knew about the problem and had fixed it. So the latest version of Cisco software was not vulnerable, but all the previous versions of software were vulnerable, and one of the concerns that people had was that nobody knew that, so companies that were running the older version of the software hadn't upgraded, and they were still running the vulnerable version. So it wasn't a situation where there wasn't a patch available. There was a patch available. It was just a matter of impressing upon people, A, the urgency of fixing this problem, and B, the nature of the problem so that it could be avoided in future versions of the software. Okay, no phone calls during the presentation. So what...
Unless your phone's unlocked.
Oh yeah, only for the demo during
That
the cell
means you're
phone
buying us
unlocking.
pizza. I hope the ringing phone was a Mirror Point guy.
No.
All right, so ISS was pretty pleased to have Mike Lynn do this presentation at first, but Cisco wasn't so pleased. And the Cisco version of this is that Cisco didn't have a problem with talking about the vulnerability, but what Cisco didn't like was they thought that the presentation was too specific. It pointed too much to the parts in the Cisco code that were problematic, and they didn't want you pointing to those particular parts of the code. Now the code that Mike Lynn had wasn't Cisco's source code. The code that Mike Lynn had was code that he had decompiled from the binary that comes along with every Cisco router. He basically decompiled it, and he was looking at the machine code. It wasn't source code, but anybody can decompile the code, but Cisco didn't want him showing any of it in his presentation. And what ended up happening is that at the sort of the midnight hour, ISS, the employer, and Cisco entered into some kind of deal where they agreed that Mike Lynn wouldn't give the presentation. Well, Mike Lynn wasn't involved in this. He didn't know what it was about. He was told he wasn't allowed to give his presentation. He decided, forget that, this is serious business. I'm going to quit my job and I'm going to give this presentation anyway, which is what he did the morning of this, I guess it was a Thursday, and I arrived that Thursday afternoon, and by Thursday night he'd been served with a lawsuit. So I became involved in this case and decided that I was going to defend Mike in this lawsuit, and in a sort of epic marathon of being in Vegas, seeing my parents who live there, and doing legal stuff, we managed to settle the lawsuit inside of 3 days. But it raised these very serious and very interesting questions about the law. So, I'm going too far. So what was the claims in this lawsuit? Well, he was sued by both Cisco and ISS, and they made 3 claims against him. The first claim was that he violated Cisco's copyright by publishing Cisco code in his presentation. Okay, so these little pointers to the machine code. The second claim was that he misappropriated trade secrets by distributing this information about the Cisco product. Who was it who was interested in trade secrets before? We're going to talk about that kind of a lot. And the third thing was that he had violated his non-disclosure agreement with ISS by revealing this presentation that was information about Cisco, but information he had developed while he was an ISS employee. So let's take these sort of piece by piece. My question then, the big question here posed by this lawsuit is, do copyright, trade secret, and contract law conspire to stop people from talking about what they discover in publicly distributed products? Well, copyright is the first question, and the question then is, well, is this machine code copyrighted, and what rights does Cisco have in it? Well, we know that source code is copyrighted, even though, you know, it's not the sort of necessarily the most artistic or expressive type of medium. And there are cases that say that even binaries or object code enjoy some copyright protection. So we could probably say, well, maybe the machine code is copyright protected as sort of a derivative of the source code for Cisco. But he wasn't publishing the machine code or making copies of the machine code. He was only using little snippets of it to illustrate his point about where it was that there were problems with this particular version of the router code. So it's clearly fair use. He's publishing it for the purpose of showing that there's something wrong with this product. And one of the quintessential, sort of the epitome of fair use uses is to make copies of something so that you can point to it and criticize it and critique it. And I have here on my screen one of the definitions of fair use. Fair use can be a lot more complicated than that. These are your typical fair types of uses, but there's this 4-part test when you weigh the factors whenever you want to know whether something's fair use. But this is pretty obviously covered. Okay, what about trade secret, the second claim? There's your 4 factors. Well, trade secret law protects things that are, that's right, secret. And something is a secret for the purposes of the trade secret law if the owner takes steps to keep it secret, to keep it from being publicly known, and if it derives independent economic value from the fact that it's not widely known that is not known to the public. And if that's true, if it is a secret under trade secret law, then the law prohibits people from misappropriating it. Okay, so you can't misappropriate it. Misappropriating means either gaining it in an improper way or disclosing it without authorization after you obtained it in an improper way. Okay, this begs 2 questions when we're talking about Mike Lynn. What is an improper means and who can disclose it? Well, improper means is defined in the statute. And it says improper means is theft, bribery, misrepresentation, all these things, but it's not reverse engineering. Reverse engineering is specifically stated to be a proper means of discovering things. Why is that? Well, we don't want to stop people from examining or exploring the stuff that's in their world and figuring out how it works, as a general rule.
Yeah.
You know, the definition of, well, don't get to the end of my presentation yet. So, you know, if you think about what is reverse engineering, you know, there are computer science definitions, but even the law recognizes that reverse engineering is a pretty broad range of activities. And courts have said reverse engineering encompasses everything including reading about the program, observing the program in operation, performing a static examination of individual computer instructions, and performing a dynamic examination of the individual computer instructions as the program's being run. So this very broad definition of reverse engineering, and we want to let people do that. So reverse engineering or independent derivation alone, and that's an important word in the statute, shall not be considered improper means. So Mike Lynn, reverse engineered, should be fine. Yes?
So you're saying that there was never a contention that that Cisco had provided ISS and Michael Lynn this information, but rather that ISS had a contract with Cisco that ISS was going to attempt to reverse engineer this stuff?
ISS and Cisco did not have a contractual relationship about this research that Lynn was doing. ISS bought the Cisco router, gave it to Lynn, and said, here you go. Now, the only kind of contractual relationship they could have had there would have been the end-user license agreement for the router software, and we're going to talk about that, because that's an issue. But they didn't have it. It wasn't like Cisco provided ISS their source code under NDA,
Right.
and then Mike Lynn was covered by that NDA as part of being with
That was
ISS.
something
They
that
were
was
kind of
not
competitors.
made clear in the various news reports on this.
Yeah, it wasn't made clear because it's a really bad fact for the plaintiffs, right? Because they would love to have had a contract that said, hey, you guys promised not to do this, except if they had a contract that said, hey, you promised not to do this, then it would have been ISS that had violated the contract, because that's the company that would have made the contract with Cisco, and they would have been the ones who had been in trouble. But instead, they were co-plaintiffs in this case, so they couldn't very well go against each other. How could they make that claim without and go against Mike Lynn when ISS would have been equally culpable under that sort of theory? So they didn't raise the EULA claim, and they didn't raise an NDA claim, and there wasn't an NDA. The only NDA that there was for Mike being an employee of ISS. And his contract with them said, I won't disclose ISS's confidential information. Whether the information he discovers about Cisco while he's working at ISS is ISS's confidential information is, I don't know. I think that's, I personally, because I'm a lawyer, I could argue it both ways, but it's not what the contract's supposed to be guarding. The contract's supposed to be guarding stuff about ISS,
well,
not the stuff about Cisco that ISS wants him to disclose at the Black Hat conference, at least until the point where Cisco gets kind of mad.
But if ISS asserted that they gained some financial benefit by knowing this information, that they hired him to find out for them in their research, it became a work for hire, that he created a trade secret of ISS's with this. They could have argued something like that.
It can't be a trade, yeah, we could, well,
He
I
was
don't,
hired to investigate this and try and find this sort of thing, and they have a way of capitalizing on this by trying to perhaps develop some product that closes this external.
right, well, initially their way of capitalizing it was gonna be to brag about the fact that their researcher found it. And then when Cisco got mad, their way of capitalizing on it was gonna be to hide it so that Cisco didn't get pissed. But either way, I'm not sure it's the type of thing that gets to enjoy trade secret protection. We'll talk a little bit about that in a second, yeah.
Well,
wait.
You say up there by California law, ISS is in Georgia, and Las Vegas is somewhere to the east of the California state line.
It is. So why was the lawsuit in California? Oh, so why am I talking about California law? I'm talking about California law because the lawsuit was in California. Why did they bring it in California? Because Cisco's here. Which was
Cisco's
great
not
for
in
me,
Maryland.
because
Cisco's not a Delaware corporation?
even though all corporations are Delaware corporations, but their principal place of business is here, so here is the appropriate jurisdiction and venue. We could have always challenged jurisdiction on the grounds that Mike Lynn never was here or had been here. They would have some arguments against that, but I never wanted to challenge jurisdiction because I'm here. So it's actually good. His free lawyer is here, so it was pretty good for me, and so we didn't challenge it. We have a lot of internet cases that get brought out here where the jurisdiction might not be appropriate, where we end up not challenging it because the free lawyer is here. So, you had a question?
It's an observation.
You'll hold on to it.
Yeah.
Okay.
Go.
So, so here we are with the trade secret. So then I talked a little bit about the nature of the non-disclosure agreement, and I talked a little bit about what the EULA problem would be. And so I think what I'm showing here is that alone, each of these claims should fail. The copyright claim should fail for fair use, the trade secret claim should fail for reverse engineering, totally legitimate defense, and the NDA should fail because the NDA covers like ISS stuff, but it doesn't cover the Cisco stuff because there's nothing there unless it's the EULA. And that brings us to this problem, which is about this part about reverse engineering or independent derivation alone. So as the case progressed, one of the things that they said is, well, he didn't get it just by reverse engineering. He reverse engineered in violation of our contract. He reverse engineered in violation of the EULA. So the interesting question here is, what effect does a non-disclosure agreement or a EULA have on this trade secret question if they say you can't reverse engineer? Well, we know from the previous speaker that non-disclosure agreements are the usual way that people keep their trade secret secret. It is a way for a company to disclose information to insiders and yet have it retain its secret value. The question is whether you can do the same thing through EULAs with outsiders, with members of the public who are not part of your company, who are not working with you, who are purchasers of a product that you inject into the commercial, into the stream of commerce. Can you turn something that wasn't a trade secret, that was something you publicly disclosed, Cisco router code, into a trade secret by slapping a EULA on it that says you can't reverse engineer? Okay, so, or is it just, if I reverse engineer, did I just breach the contract? Or is it not even an enforceable term in a contract?
Is a EULA a contract? There's no signature, there's no proof on the other end, and it's not negotiable.
And in a lot of cases,
So,
isn't even able to be looked at until you've somehow clicked an agreement.
Okay, so the EULA law is kind of complicated, but the basic parameters of contract law are someone makes an offer, someone accepts, each person gets something in the exchange. That's your basic contract law. So the question is a EULA, the way it works, an offer and an acceptance? Now, when the user, let's pretend it's software that we're talking about. When the buyer of the software gets the software, the question is, do I ever see the license terms? Do I ever have the chance to see the license terms? So what the cases have held is that if I get a chance to see the license terms, that's pretty good. So BrowseWrap, I don't see the license terms, I never see them, I don't know anything about them, probably not a contract. Because I didn't agree, I didn't know that things were there. So there's a lot of cases that say BrowseWrap sort of doesn't work. That's why very few companies actually use BrowseWrap these days. Most companies have some kind of click wrap or shrink wrap where it's on the box or you have to click I agree as you install the software. If you click I agree as you install the software, most of the cases say you've entered into a contract. You clicked I agree. I know you didn't read it. I know nobody reads them, but it's still a contract because you clicked I agree. So that doesn't make very much sense, really, because some of these EULAs don't have, or some of these EULAs are like 100 pages long, and all the terms are buried in all of this legalese. A lot of them you can't print out or save to disk and read them later. A lot of them you have to click OK right then and there, and a lot of them, sometimes you're not even shown the EULA until after the software already installs, or you don't, or you know, it's in the box. If you don't, and if you don't agree, you can't take it back and all of this. So the cases that have said that EULAs are okay, generally it's okay if you click I agree, but when you have these, and they say, and if you don't agree, you can uninstall it, you can take it back. So we're looking at challenging some of these contract formation, you know, this idea that contracts are formed this way on the grounds that you can't take it back, you can't print it, people can't meaningfully read it, it's not really a meaningful kind of meeting of the minds over these terms because you're not really, as the user, you're not really seeing it. In fact, many of these companies actually engineer the install process so that people don't read the EULAs. And you are in this situation where the contracting is basically fake. It's a legal fiction that you're actually entering into an agreement. And many of these EULAs have particularly onerous terms, like no reverse engineering, no benchmarking, no criticizing our product. You'll pay for our lawyers, including their travel time, if we ever end up in arbitration. And if we do, your recovery is limited to $1 or the price of this software, whichever is lower. So, yeah.
It's important to note that the meeting of the minds is what makes a contract.
Right, the idea is that it's the meeting of the minds. It's offer and acceptance, but the idea in that is that it's meeting of the minds. So you can have this kind of constructive agreement where I don't say I agree, but I do something that manifests my my willingness to be bound by the contract, or manifests that I knew what the terms were and I accepted some other way. So one of the most disturbing lines of cases are the cases that say that where people have notice of what the contract terms are and they continue to use the product or the website after they have notice, that they've basically consented to those terms, even though they never said I agree or clicked I agree or anything like that. And the problem with that is you can just basically enforce any terms on anybody at any point in time by saying, okay, now you use my website or you continue to use this software, it means you owe me, you know, $400 and there's nothing much you can do. You may have no real, you know, actual choice there. Okay.
What's the argument for, you said one of the conditions of a contract is the contractee gets something, the contractor also gets something.
It's a beautiful term in the contract law called mutual consideration. Everybody gives each other something, consideration.
But you click on I agree, you've already paid for it. It's not like if you didn't agree and it sat on a shelf, they already got the money.
Right. This is one of the problems with this line of cases is that you've already done the deal. I give you the money, you give me the software. And now you're giving me all these
under the UCC.
Now you're giving me all these restrictions later on, and I haven't, and now it's like you're saying, okay, yeah, it's like you're saying, now you're trying to take away something after I've already paid for the thing I've got. So this thing is called terms after, which is like, can you impose these terms following? And there's a line of cases out of the 7th Circuit that started to say, yeah, that's okay, because you know these poor companies with needing to do this mass market licensing have to be able to like get people to agree somehow, and it's just too onerous to make them tell people what the contract terms are ahead of time. So we're going to let them do terms after, and if the people don't, you know, let them offer these additional EULA terms after people have already purchased the item, and if you don't like it, you can take it back. Now there have been lawsuits here in the state of California against software companies on these grounds, but kind of focusing on the ground that you can't take it back. Because once you buy it, you can't go back to CompUSA. They won't take it when the package is opened and the software's out, and there's no place to send it back to, and you know you can't get anything that promises that when they get your open box of software that they're going to send you your money back or anything. They're going to say go to CompUSA and get your money. So there have been lawsuits on exactly this grounds, but the case law says that if it's possible to return it, then we're going to let this kind of contracting where the terms come after happen. Yeah.
I was just wondering if somebody purchased the actual router on eBay, used, so there's no actual purchase from Cisco, the software is already installed, there's no EULA to agree to because it's installed. where are they then?
Yeah, so a subsequent purchaser of a machine that has software on it doesn't have to click through on the EULA to agree. So then the question is this person bound by the terms of that contract? And one argument, and you could say no, because I never agreed, I didn't click anything. But then, if I start reverse engineering the code and Cisco calls me up and says, hey, by the way, there's a reverse engineering restriction on that code. It's part of our, license agreement. You're not allowed to reverse engineer it. If it's true that I can constructively accept by having notice of the terms and continuing to use the product, then when I continue to use the product and continue to reverse engineer, they can say, hey, they told you, you knew, you kept using it, you didn't return it, you're still bound by the terms and conditions.
That runs afoul of doctrine of first sale.
It does run afoul of first sale, which is the doctrine that says that once I, the copyright owner, put something into the stream of commerce, I no longer have any control over the physical entity that contains that item. That's why we can have a used bookstore, or that's why you can, sort of sell your CDs and that sort of thing. With software, copyright owners don't like that idea as much because they think it's much more likely that I've still got a copy of the software. When I give you the book, I don't have the book anymore. But if it's software, that's much more likely that I still have the software on my machine and I've just given you the CD or something to download it, so they don't like it. And it makes the doctrine, and all of this digital technology has really put a lot of pressure on the doctrine of first sale and on people's first sale rights. It's made it a lot harder for consumers to exercise that right, which is something that's been enjoyed for many, many years of the copyright law. Yes?
So backing up to the onerous burden you were talking about.
Yes.
What I'm hearing is that the courts were one-sidedly only being concerned about onerous burden to the seller and not the buyer.
Right.
The buyer has to go through all this stuff to return the software, get the money, has to spend time and everything, and that's okay, but it's not okay for the company to spend the time.
Right, exactly. The law, in these cases, the law has demonstrated much more interest in protecting the company from the burden of having to make money from all of us, as opposed to us from the burden of having to figure out, just exactly how is this company trying to screw me with this EULA.
Where's some district? New York,
Illinois, I think this. Yeah, I think this is Illinois. There was a. Did you have a question, Heather? Did you want to ask a question?
Portland actually originally described its software licenses for some of its compiler products as, with the heading, just like a book, and then it described a number of points where they wanted the software copyright on their software package to match that of a book, including describing explicitly that when you give a book away, then you actually don't have it in your hands, so when you give the software away, you have to get rid of it so that it's not in your hand.
Right, exactly. And we continue to believe that if you do that, if you give software away and you no longer have a copy of it, it's okay. But it is true that a lot of EULAs now try to restrict the right of first sale and say you promise not to sell this software or to give it away. Many EULAs have started to say that. Is there a question in the back over here? Yes.
Just a point, and actually my company came up against this recently with regard to purchasing, say, Cisco equipment from eBay or something. And Cisco actually says what you've purchased is the physical hardware and not the software that's in it. That's protected by their license, and if you want to use that software, then you have to
really selling me software, that they're just giving me, I'm paying all this money for some very conditional permission to use it that allows them to put restrictions on me that go beyond the restrictions that copyright law would allow. That just seems to have had a lot of legs in the legal system. And the UCC considers that, which is the Uniform Commercial Code, a proposal for how states should treat commercial transactions, considers that as a possibility, this distinction between something being the sale of goods and something being the licensing of something, just permission to use something where ownership remains. Now, what's the difference between me owning it, but still the copyright being with somebody else, and it being licensed to me, and I'm not really owning it? In the law, it's sort of fuzzy, because this whole idea of ownership is really about property rights. And in the law, we think of property rights as a bundle of sticks. And each stick is something that you have the right to do with the item, and it depends, like, what sticks did you get in the transaction. So this is really just kind of a battle, when I talk about sale of goods or licensing, that's kind of legal jargon for how many sticks can the seller retain just to kind of make it a little less jargony and a little more clear. It's just what are they being able to, what rights are they being able to retain, and correspondingly, what rights am I, the consumer, not being able to get? So the question, as I asked before, is what does all this EULA contracting stuff that it seems like people are really familiar with the problems and the concerns about these EULAs, what does all this mean for trade secrets and for reverse engineering and my right to reverse engineer and figure out what the deal is with programs? Well, we'll go to the DMCA in a second. Well, the problem is, we all love the DMCA. It's a full employment act for lawyers, really. We haven't had cases that have really considered very much this question of what do EULAs mean for reverse engineering and for trade secret law. There's only one case that came close to answering this question, and this was the case of DVD CCA versus Bunner, and this is one of those cases that involves DCSS. DCSS is a program that decrypts DVDs, CSS being the encryption algorithm that scrambles DVDs. DCSS was written by a Norwegian guy, and he then published it on the internet, and many people decided that they were going to also post the program on the internet. The DVD Association decided to sue one of those people here in California, Mr. Bunner, and it said, Mr. Bunner, you are violating trade secret law, our trade secret law. Our trade secret. CSS is our trade secret. DCSS reveals the nature of our trade secret and breaks it, and you are publishing it on your website, so you're violating trade secret law. And Bunner said, hey, first of all, I didn't misappropriate the trade secret. If anybody did, it was Jan Johansson, the Norwegian fellow. And he didn't misappropriate it because he got it by reverse engineering it. So you can't stop me from publishing it, and I didn't misappropriate it anyway, and it wasn't misappropriated in the first place. So what's the parallel here? Reverse engineering, EULA, and then the publication, which is the part about how Black Hat, the conference, got in trouble and was sued for letting Mike Lynn have a format in which he could talk about his presentation. So here we have the two issues again. What does it mean to get something by improper means, and what kind of restrictions can they put on people disclosing the information that they obtain? Okay, so in the Bunner case, the court said, well, we don't know what the law is, and we don't know what his deal was in Norway, but we have reason to believe that he got these DVDs pursuant to a license, and the license said you're not supposed to reverse engineer CSS, and so he can't reverse engineer CSS because he's doing it in violation of the license. So it wasn't proper means, even though the California law says so. Let's just go back. Even though California law says that it's proper means, because he did it in violation of this EULA. And so the Bunner's team countered, hey, you can't prohibit reverse engineering in a EULA in Norway. That's just like not allowed. They're much more advanced than we are, and they just don't let that happen. And they said, we don't know that that's true or that's not true. We think that at least at this point it's an open question in Norway, so we don't agree with you. We think he probably got it by improper means. We think that you knew or should have known that he got it by improper means, even though you weren't the one who misappropriated the trade secret. But because you knew that somebody else got it improperly, we're going to hold you to the same standard, and we're going to say you also are not allowed to publish the information. So this is the thing: you know somebody got it in an improper way, you can't publish the information. So they issued an injunction against Mr. Bunner. Yeah.
My favorite part was where DVD CCA accidentally entered the source code in question into evidence in public. Unfortunately, of course, trade secret law wasn't their big weapon anyway.
Yeah, it's like if it's on a T-shirt, it's not a trade secret. It should be a law to that effect.
We have a T-shirt that says that.
There are T-shirts sold that have
Yes.
DVD, CSS.
Yeah, there are those T-shirts that are sold, and I'll talk a second, when I talk about the DMCA, I'll talk a little bit about why those are okay, probably, and how they're, why those are probably okay. But I want to just for a second focus on this idea that if you know that something was derived illegally, you're not allowed to publish it. There's a long history in this country, starting back with the Pentagon Papers and going, recently to the case of Bartnicki versus Vopper, which I'll explain in a second, that says that even when you know that something was illegally obtained, that there may still be a right to publish it, okay? In the Pentagon Papers case, a Department of Defense employee leaked this information about the history of United States involvement in Vietnam to the New York Times. And the New York Times wanted to publish it, and the Nixon White House sued them to stop them from doing it. And the New York Times won in a very splintered opinion, but one where they definitely, came out ahead. The Supreme Court said the New York Times has a right to publish this stuff. It's of utmost national importance, and yet the First Amendment requires that this information that's of public importance go forward and be published. In Barnicki versus Vopper, it was a case involving a radio station that had obtained an intercepted cell phone or cordless phone call between these two union operatives who were involved in this kind of local battle over some labor law issue, and the union operatives were conniving over the phone, and this phone call was illegally intercepted by somebody in violation of the Wiretap Act, and then the person turned the tape over to the radio station, and the radio station was playing it on the radio, and the union people sued and said, hey, you can't play this because it was illegally obtained. And the Supreme Court had to consider the question of these statutory privacy rights that are preserved by the Wiretap Act versus the First Amendment right of the radio station to publish this information that was of public interest. And the court said the First Amendment wins here. This is of public interest. The radio station's publishing it. They know that the person got it illegally, but they're still allowed to publish it. But yet, why don't we have that right when it has to do with trade secrets? If the nation's security in the Pentagon Papers case can yield, and that makes our nation better, why doesn't that happen with trade secret law? So the Bunner opinion didn't address these issues, and we still don't know. Eventually we're going to find out because there's more and more of these cases as time goes by, since we have much more of these intellectual property claims that are being raised. All right, so I think this raises a couple of interesting questions, and I told you I was going to have answers, but actually I don't. But here are some of the questions I think that this really raises that we're going to need to answer as citizens and as lawyers in the future, or lawyers who are also citizens. Whose press entitled to the deference that the law gave the New York Times or the local radio station? Does the definition of press need to be broadened now that we don't need a printing press or a broadcast transmitter in order to reach a mass audience? Or does the fact that we have the internet to communicate mean that we need to be more careful about who gets to wear the mantle of media freedoms? Is Black Hat liable when its speakers reveal information that they obtained improperly? And does it matter if they know that the information was obtained in violation of the EULA, or shouldn't that matter at all? If we enforce these EULAs and let the EULA tell us when we can't reverse engineer, how are people ever going to find out anything about the software that controls their world and that runs their programs and that runs their machines? What are we going to do about this? Well, reverse engineering has generally been seen, as you can see from the definition, it's generally been seen as something that's like this, kind of exploring, investigating, and has been protected under the law. It's not like a right, like a right in the Bill of Rights, but it is something that has this great social benefit, and that's been recognized by courts in numerous copyright cases where they've said, well, if you're making copies in order to reverse engineer, that's a fair use. We recognize that reverse engineering is, one of these important things, and actually contributes to the purposes of the Copyright Act because it lets people create new things by understanding how old stuff works. So we understand that there's limits on reverse engineering through EULAs, and that the parameters of those limits are a little bit scary, and we're not sure exactly what they are, but that courts are generally tending to uphold EULAs and say that they're valid contracts. There's another doctrine that also puts a lot of pressure on the reverse engineering right, and that's the Digital Millennium Copyright Act. Now, the DMCA has a number of different provisions, but the provision I'm going to talk about right now is Section 1201, which is the anti-circumvention provision, and this is basically what it does. It prohibits circumvention of a technological measure that controls access to a copyrighted work, and it prohibits the manufacturing and distribution of tools, technology tools, that are primarily designed for the purpose of circumventing, that have limited commercially significant purpose other than circumventing, or that are marketed for use in circumvention. Okay? So there's a couple things to notice about this. One is that it's not about preventing copying of copyrighted works, it's about controlling access to copyrighted works. Those are different things. And it's not just about the act of circumvention, but also about tools which enable circumvention. Those are the two kind of parameters. Yes?
That last sentence, marketed for use in circumvention, something that's given away for free, would that be tied to marketed?
Yeah, I don't think that marketed means that you're selling it commercially for money. I think that the courts would say that marketed means that in the way that you distribute it, whether you give it away for free or whether you're selling it or whether it's, got advertising associated with it or whatever your business model is, it's what you say about the product. I think that this is actually kind of the trend, and I think that this marketed for use thing is kind of the reason why the Supreme Court came out the way it did in the recent Grokster case. So in Grokster, whether peer-to-peer file sharing technology is legal, the court said, well, the technology is legal if it's capable of substantial non-infringing uses, of stuff other than copyright infringement, but we're still going to hold the company liable if they tell people, hey, by the way, you can use this to copyright infringe. It's this feeling that, even if the technology's okay, you shouldn't be able to capitalize upon its illegal uses by telling your customers, look, this is, or encouraging your customers to use it for the bad reason. It's kind of like a, we don't like bad guys rule, which, I don't like a we don't like bad guys rule, but I think that's what this provision is trying to get at. So, the DMCA, the DMCA has been used in cases to deal with several different things. It's been used to attack mod chips, which you can put into your Xbox so that it runs non-Xbox games. It's been used to attack DCSS. It's been used to attack Adobe ebook decryptors. It's been used to attack printer cartridges, and it's been used to attack garage door openers. Now we can see perhaps how we get mod chips and ebooks, but how we get to printer cartridges and garage door openers as being something that's arguably illegal under the DMCA is probably, or at least I hope, not what Congress intended when they passed the rule. So what's the protections under the DMCA? There are basically 3 protections or 3 exceptions that kind of try to leave some room or purport to leave some room for research about products that you legally possess. But the research, and they are the security testing exception, the encryption research exception, and the reverse engineering exception. But you'll see that all 3 of them are very narrow.
Why didn't you also list the library exception?
The library exception, there's a number of exceptions. For example, there's also exceptions for libraries, and there's exceptions for censorware to find out what sites they block. And I sort of picked these 3 because I thought these are most about the way that people here will probably be trying to explore the technology that they own. But it's a good point, I appreciate it, that these are not the only exceptions. There are other exceptions, and you can kind of see what kind of special interest groups Congress deigns to care about when you look at these exceptions, because see, libraries, we don't want to make the libraries mad because everybody knows librarians are good. Oh, the children, we have to do it for censorware to protect the children. We have little things like that sort of show who managed to get their voice heard before Congress when these exceptions were being drafted. Okay, so the security testing, I'm not going to read these, but I'm just going to show you. The security testing exceptions narrow. You have to be, the information that you get can only be shared with the developer of the system. If you share it with anybody else, you don't fit in under this exception. The encryption research exception, you have to be a professional cryptographer. Okay, so I don't know if anybody needs a business plan, but I think certifying people to be professional cryptographers might be something that people would be willing to pay $20 for if they want to make sure that they're coming in under the encryption research exception. And this is another one of those things that I really don't like about this idea of who's a bad guy. It's well, if you're a legitimate encryption researcher, from a university, you're okay. But if you're some guy in your basement who's interested in figuring things out, and we don't like the way you look, then maybe you're screwed.
500 years ago, we called those guilds.
Well, it's not like computer security is a field that really grew up in the university, right? So why are we pretending that somebody with some kind of university affiliation or who looks professional is going to, give us anything better in this field than the people who've been giving us good stuff in the security field for, since
Wasn't Stanford
computers.
started because a couple of people didn't look professional enough out on the East Coast when they wanted to give them a lot of money? I love my job, but I don't know the Stanford origin myth. I thought it had something to do with Stanford's wayward son, and maybe he's the one who didn't look right.
He died.
Right, that's
I get sometimes. That is the official story. The official story is that the Stanford family founded the university in the name of their son who, if I remember correctly, drowned.
Yeah, and you notice you work at a junior university.
Yeah, well, I think it was Stanford who was the junior, but yeah.
Well, one of the fun things, I forget who he asked when he said, how much does it take to start a first-class research institution? And they gave him a number that they thought was 10 times as much, and he went for it.
I've learned more about my employer tonight. You know, the law school's on Nathan Abbott Way, and every year I ask a couple people, I say, who was Nathan Abbott? Like, who is this guy? Nobody knows. So we don't have a lot of, apparently we need more team loyalty over there at Stanford. Okay, finally, the reverse engineering exception. It's only okay to achieve program-to-program interoperability. Not okay for program-to-device interoperability or that sort of thing. The reverse engineering has to be necessary, and the only disclosure of the information can be for the purposes of enabling that interoperability. It can't be related to any kind of infringement at all.
You want these things to be as poorly written as they are, because that's how they fall down.
Well, I disagree, because these things have been tested in case after case after case, in the DCSS cases, in the trial court with the printer cartridge case, and in the mod chip cases, and they fail because they're so narrowly drafted. And it'd be better if they were poorly drafted and broad, but they're poorly drafted and they're very narrow, and so it's very easy to find something in the exception and say, well, you don't get this because you didn't match it. It's like in the DCSS case, they said, well, you don't get the reverse engineering exception because you're not achieving program-to-program interoperability. You're trying to make it play on a Linux box, and that's not a program. That's a machine.
Excuse me?
Excuse me, Linux isn't a program?
Device.
My comment was in hoping that this entire form of law would fall down by being poorly written. If it was well written, then it might actually stay around for 100 years.
Well, we'll see.
So far, it's stayed around for way too long.
I'll be taking bets on this theory at the end. All right. So this is about the reverse engineering. Okay. So then the question is, what do these things? What do these things mean? And I mentioned the garage door openers and the printer cartridges. In the end, these cases came out okay, but what happened was Lexmark, a printer company, challenged a maker of compatible generic printer cartridges for circumventing access controls that allowed the printer cartridge to run software that was stored inside the printer. And Lexmark said, oh, when you did that, you accessed our copyrighted program inside the printer. That's not allowed. And in the garage door opener case, Chamberlain, a garage door opener, sued a company that made universal garage door openers that open all garage doors and said, well, when your garage door opener figures out what our rolling code system is and communicates with the software that's inside our garage door opener and opens people's doors, you're circumventing our little rolling code handshake and you're accessing the software that's in the garage door opener, and that's not right. That's a violation of the DMCA. And eventually, in both cases, the court said, well, you have authorized somebody to do that because when the customer buys the garage door opener, they're authorized to access the code to open their garage door. And when the customer buys the printer, if you don't have a EULA, you're authorized to access the software that's in the printer cartridge. So you guys lose these cases, and then the next day, the garage door opening companies and the printer companies started putting EULAs on their products. And the EULAs say, you promise to only use our garage door opener with our garage door, you only use our garage door machine with our garage door opener. You promise to only use our printer with our printer cartridges, and that's in the EULA. And so the question is, these cases came out okay, but will they come out okay under the DMCA next time, or will these products be held to be illegal? And remember, there's two things. One is the question is whether you'll be allowed to circumvent. In other words, can you use your printer? Can you use your garage door opener? But maybe even more problematically, because maybe there's some people in this room who might be able to figure out how to do that anyway, will any company be able to make a product that helps people open their garage doors or use their printers with other printer cartridges?
Or when you buy a garage door opener, are you then permanently bound to that company forever? Can their EULA then say, and you're never allowed to take this out and put in a different one?
Right. And we've been doing, at the school, we've been looking at, this semester, at a lot of EULA issues, and we've decided to figure out who would be the most likely, who would courts be most likely to think is a bad guy And who would courts be most likely to look at their EULAs askance and start really seriously thinking about the question of whether we're going to just say anything goes with EULAs, or we're going to actually try to figure out whether there's some limits to the kinds of rights that people can contract away with these things, and we decided that it would be spyware companies. And so we've been investigating spyware company products and spyware company EULAs with an eye towards trying to challenge these and get courts to recognize that there's something wrong with the contract formation process with EULAs, this terms after thing and that sort of thing, and that there's something wrong with the kinds of terms that are in EULAs. Some of them are just too onerous for people to take on without having really clear notice. And some of them are just too onerous for people to take on without it being really negotiated. And some of them are just too dangerous to let people take away at all, like the term that says, you promise not to review our product without our written permission. And it shouldn't be. I mean, if 99.9% of the people in the world don't care about reviewing the product, they can just go ahead and sign the EULA, but no one will ever be able to review the product and tell them, hey, this product sucks, you shouldn't buy it. And there's this strong public interest in having that information out there, even if each individual contracting person doesn't care. So we're looking at that issue and trying to see if there's something that we can do about it. And what does this all have to do with cell phones? I'll take your question and then I'll say why it has to do with cell phones.
You suddenly got my attention. I'm sorry, I should have worded that differently. It's been a very long day for me. You're saying that there are people who are actually saying, putting in the EULA that you're not allowed to review their product?
Oh yeah, that's horrible.
Where you been? First Amendment?
It's not a First Amendment problem.
Right.
It's not a First Amendment problem
NDA,
because you can waive your constitutional rights.
Yes.
Well, some of them.
You can waive, what constitutional rights can't you waive? You can't say, I mean, you can't ask somebody to kill you, except in some states. But otherwise you can waive, otherwise you can waive your constitutional rights. You can waive your Fourth Amendment rights, you can waive your...
Worth the paper that it's printed on because it's against the law to waive your own rights.
No, it isn't.
It's not. People waive their rights all the time.
Every time you sign an NDA, you waive your right to free speech on a particular topic.
When you join the CIA, they can make you sign a contract that says, I won't talk about stuff in the CIA. When you work at a place, if you say, I'll stay here for a year, you're waiving your right to leave earlier. When you plead guilty, you waive your right to a jury trial.
And the people who were not allowed to go back into the Oakland Hills in order to salvage what was left of their houses were told, well, we can't let you sign a waiver because the waiver wouldn't be worth the paper it's written on because we can't allow you to sign away your own rights. And that's why a lot of people were not allowed to sift through the ashes of their own houses in the Oakland Hills fire.
There may be some restrictions on the kinds of waivers you can have for something that's like inherently dangerous, like for products or for incidents that are inherently dangerous. But even that's usually not the case. So there isn't a general rule against waiving your rights. In fact, the general rule is quite the opposite, that you can waive your rights. It may just have been that they didn't want to take the chance that these people would get hurt and be upset later on. But there isn't a general rule against waiving your rights.
We could argue this. There's actually a legal thread that goes all the way back to indentured servitude just after the Constitution was signed. But let's continue with your stuff, because we're running out of time and this is a distraction.
But it's just simply not true that people can't waive their rights. They can. People waive their rights every day. That's just the way that it works. So then the question is, okay, I don't have more slides, but the question is, okay, what are we going to do about this, and what are we going to do with these EULAs, and what does this all have to do with cell phones? So I became interested in this it's hard to think about exactly, I like to think of myself as being a civil liberties lawyer, which is sort of distinct from the lawyer who does actually like to make money. And I think that I am, trying to help in the civil liberties world. So why do I care about cell phones? Well, I got a call from somebody who sells cell phone unlocking software. And basically, cell phones are set up so that when a company sells, like Verizon, which I use, sells me my cell phone, it has my cell phone configured so that it'll only work on the Verizon network. And if I want my cell phone to work on a different network, then I have to, it won't. Because the software in the phone, when it connects to the network, says to the network, are you the Verizon network? And if it doesn't know the secret handshake that says, yes, I am on the Verizon network, then my cell phone won't work, it'll kick off. So I can get my cell phone modified, or I guess if I'm technological enough, I can modify my cell phone myself to override that secret handshake. And this person who sells the software that does that got a nasty letter from a cell phone company saying your software violates our rights under the Digital Millennium Copyright Act because your software circumvents this secret handshake and allows people to access or run the software that's inside their phone. And that means that when we sell you your phone, you're going to use your phone on the network we tell you to use it on. So if you want to go to Europe and use it on a different network where you don't have roaming charges or long distance, you can. If you want to sell your cell phone to somebody else and they're on Sprint, you can. If you want to recycle your cell phone and give it to somebody else in Africa so they can use it on a network there, you can. So you can't do any of these things with the cell phones. So what we decided to do with this is we have this opportunity before the Copyright Office, and every couple of years the Copyright Office considers what exemptions there should be to the DMCA. What kinds of works should be exempted from these anti-circumvention rules, and we decided that we were going to file comments on behalf of people who want to unlock their cell phones to say that the cell phone software inside the phone should not be something that you should be able to circumvent the secret handshake to access the software and run your own cell phone. And we've been thinking about how to talk about this cell phone thing in a way that will work also for printers and also for garage door openers and also for other devices that have firmware that is protected by a secret handshake that the company is using to try to tie you in to corresponding goods and services, whether it be cheaper whether it be refilled printer cartridges or garage door machines or the network that your phone will run on. So these exemption requests to the Copyright Office are due December 1st, and we'll be filing those on behalf of a man who is a massive cell phone recycler and repurposer, which he does in conjunction with the Environmental Protection Agency, and a person who is a vice president at a company and travels all over the world and needs to use his cell phone. Okay. Yeah, it's 9:30. That's the beer time, but I'll take two questions and then we can be done.
Is that your personal Verizon phone?
This one?
Yeah, not company?
Yeah, personal.
Did you give them your social security number when you got the contract?
I usually don't, but it may have been that they wouldn't give it to me otherwise, in which case I
tried a bunch
did.
of cell phone companies and they wouldn't.
Yeah.
Verizon lost the data on 45 million customers.
They didn't send me one of those notices that tells me that I was one of the people, but I don't think that means that I wasn't.
Yeah.
So one of the real problems with identity theft is that people use the social security number as like a universal identifier, which makes it just really easy for identity thieves to collect all the information that they want to have about you. When I was, before I got into this field and I was doing death penalty work, we used to do investigations on our clients to try to find out all the information we could about their background and whether they were mentally ill and had they been beaten and all of this stuff. And it is amazing the amount of information you can pull up about somebody with just their social security number and their date of birth. And wait, yes?
So I'm hearing that antitrust and restraint of trade laws are trumped by these other things, including ULA, and why that would be.
Yeah, this is the real question, is that it seems to me like, antitrust law requires, in order for the antitrust law to apply, it requires you to have like monopoly power in the market. And one of the things that's the problem with antitrust law is that it's hard to put it into effect in these types of situations where you clearly have anti-competitive behavior. Because not all anti-competitive behavior is a violation of the antitrust law. You have to be a player with that kind of market power. And so, a company that sells like one of my spyware companies. It's one of maybe 10 or 15 or 20 spyware companies in the field, and it's saying, it has these rules about what you can do with the EULA, or if you install this spyware, you promise never to uninstall it, or you promise to let us install whatever other software we want to on your machine. But it's hard to meet the first part of the antitrust thing, which is to say it's got market power, although it has 100% of market power over people who are infected with that software, just like Cisco, Cisco has market power, but it doesn't matter much, because even if the software doesn't have market power, they can still shut off debate if you can enforce through the EULA a term that says don't reverse engineer, don't benchmark, don't review. So there's problems with tying, printers to printer cartridges. There's problems with, losing civil rights by 1,000 cuts through these EULAs that are happening now in the absence of the trigger for antitrust law. And so antitrust law has kind of left us behind, and the companies have these things, but we don't have that much. And so what we have to do is we have to say, these things, trade secret EULAs and these sorts of things, have to start taking into consideration this kind of anti-competitive behavior, and we have to start thinking more about how we can protect the consumer and protect people's civil rights in this world of new digital contracting. So, okay, well, thank you very much for having me here.
Jennifer, can we get the slides for this?
Yeah, definitely.